Hey, everybody. Welcome to the live session. My name is Lawrence. I'm with EWOC, Emergency Workers Organizing or Workplace Organizing Committee. And we provide support and training for anyone trying to organize with their coworkers, start a union, anything along those lines, any mass act for the workplace. We know times are tough, and we know that the government is being gutted. We know CPFB, Parks and Rec, every department is being attacked one by one, and people aren't just losing their jobs, though. They're cutting funding. There's all sorts of impacts spread out throughout the country right now. And unions are stepping up amidst all of this, right? Society's pushing back. This is what we have here through EWOC. That is our focus. And so today, we're going to be talking about the NLRB, the National Labor Relations Board. We have two experts here, Abby and John, and I'm going to let them introduce themselves.
Hi, everyone. My name is Abby Frerick. I am currently the Paul Tobias Attorney Fellow at the National Institute for Workers' Rights. Before this role, I was engaged in independent organizing. I was a member of UGSDW at Grinnell College, and I worked with Amazon Labor Union and some other independent unions. And before I turn it over to John, I also just want to let everyone know that we will be educating folks about their rights, but not providing legal advice. So we're really excited to take questions and share our knowledge, but we will have to be careful about applying laws to any specific set of facts tonight. And John.
Hey everyone, my name is John Eric Haynes. I am a Minneapolis-based attorney that represents a wide variety of unions for a firm called Cummins and Cummins. I've done a fair amount of work in front of the NLRB, the National Labor Relations Board, and prior to law school also did some union organizing, some political and community organizing as well, so I've worn that hat too. Excited to be here.
Thank you both for being here. Now, we have three main questions that we're going to run through. What is the NLRB? What is it not? And both of those will encompass a lot. And then sort of what it was at inception, so you understand why it even came about. What were we looking at before and after this situation? And then we'll open up the floor to you all. So again, bottom right, you should see the option to send any questions in, and we'll monitor those. And at the end of this, we'll run through them if we have enough time. Okay. So, first question: what is the NLRB? We know it's a federal agency created by Congress, right? But please tell us what we need to know about this. Like, please define it, Abby or John or both.
Yeah, absolutely. So stepping out a bit for its scale, the National Labor Relations Board, which we might refer to as the NLRB, it's an independent agency of the federal government that enforces U.S. labor law in relation to collective bargaining and unfair labor practices. The National Labor Relations Act of 1935 is the piece of legislation that created our federal labor law in the NLRB. We may also refer to the National Labor Relations Act as the NLRA or the Act, but we'll try to say its full name. The Act was enacted during the Great Depression following numerous massive strikes, including general strikes, by workers demanding better working conditions and a seat at the table. The Act was passed to bring labor peace and create a legal structure for organized labor activity. While the National Labor Relations Act is not a perfect piece of legislation, and we will discuss some of why that is, the NLRA and the rights it provides are a tool for workers that are just ever more so now, just important to know. As an agency, the NLRB is under the executive branch, and its leadership in DC does change with each presidential administration. But there are numerous regional offices across the country staffed by field attorneys, many of whom are just wonderful, who stay through the changes in the administrations and they want to help. Those regional offices are the ones that actually process the charges in their area and that you'd be working with. You can find out where your local regional office is based just by Google or the NLRB's website.
Yeah, so thinking about, practically what this means, kind of how you might relate to the NLRB. in your role as a worker, you have a right, as Abby talked about, under the National Labor Relations Act, under the law passed by Congress, to work with your coworkers to try and improve your wages, your benefits, and your working conditions. And if the employer retaliates against you for doing that, that's unlawful. And the NLRB is the organization that investigates that and enforces your rights to work with your coworkers for better working conditions. You also have the right under the National Labor Relations Act to form a union, and if a majority of your coworkers vote to join a union in an election run by the NLRB, your employer is required to bargain with that union. And the NLRB oversees that process and facilitates the process of running union elections and enforcing your right to form a union and the obligation of your employer to bargain with a union that you form. So from a very practical point, what that means is if you're retaliated against for working with your coworkers to improve your working conditions, you say you and your coworkers get together, sign a petition, present it to your boss, and everyone gets fired, you should file a charge with the NLRB, your local office of the NLRB. Filing a charge, we'll get into the details of the form and how to do that later on. But it's a relatively simple process to file the charge and make the complaint that you've been retaliated against. The NLRB will then investigate that complaint, the regional office, staffed by field attorneys, as Abby mentioned, and field examiners, other employees, many of whom are very invested in protecting workers' rights. They will be the first party to investigate your charge that you were retaliated against, that your employer broke the law. They may ask you to provide an affidavit, provide documents, evidence to support your charge, and decide whether they think your charge has merit. That's the big decision point that they're investigating when you file a charge. So that's the initial process for enforcing your rights to, under the National Labor Relations Act, to work with your coworkers to improve your working conditions. And that's what the NLRB does, investigates those charges. It also, as mentioned, oversees the formation of unions through union elections. And how that process works is you file a petition with the NLRB. If at least 30% of your coworkers sign an authorization card saying they want to be represented by a union. The NLRB then investigates the petition that you filed saying you and your coworkers want to be represented by a union. There's procedural steps, and ultimately, the NLRB is the party that runs and oversees the union election that you may have at your workplace. The election process, if that's something, if you were thinking about forming a union with your coworkers, I think the most practical thing is to get in contact with a local union organizer or with someone from EWOC, and they can shepherd you through that NLRB process. If you're retaliated against by your boss because of your trying to improve your working conditions, then you could go directly to the NLRB yourself, and they would help shepherd you through that process. So from a practical point, that's what the NLRB does for you as a worker.
Thank you. Thank you both. And one question, one quick follow-up question I had. You said they decide whether or not your charge has merit. Are there any trends or patterns that you've noticed for charges that definitely do, charges that are murky, and charges that do not have merit?
I can say, as Abby mentioned, depending on who's in power in Washington, who the president is, Democrats generally take a broader view of your rights, and Republicans take a more narrow view. So that doesn't mean under a Republican you don't have rights. Under the law, the National Labor Relations Act passed by Congress, you have the right to work together with your coworkers to improve your working conditions free from retaliation. Donald Trump can't change that without Congress. But what he will do is try and make that as narrow as possible. So I would expect in the next 4 years it to be a little harder to enforce those rights. Doesn't mean that you shouldn't absolutely try and enforce them if you're retaliated against.
Yeah, and John can speak to this a bit more than I can, but from what I have, experienced with agents, they will also kind of let you know how they think the charge is going. If they don't think you have merit, they will kind of let you know that as well. You're not going to be in this process blind. It is an active process, but you're not there alone. It is the NLRB prosecuting the charge.
Okay, that gives me hope. Thank you for that. So that's actually now's a good time to move into the second question, which would be sort of what is the NLRB not? What are the limitations so that my hopes don't shoot to the roof or shoot through the sky? What are my limits? Give me some bounds if you could.
Yeah,
Uh,
absolutely. So the first limit is who can use it. So most private employees, which consists of 69% of the American workforce, are covered by the jurisdiction of the National Labor Relations Board. So they can use the protections offered by the National Labor Relations Act, knowing that the NLRB will or should back them up if their rights are violated. Government employees, agricultural laborers, independent contractors, and supervisors are generally excluded from the protections of the Act. Government employees and public unions are governed by state laws. So these workers likely have similar protections. They're just not involving the NLRB. So first, you just have to make sure you are covered and able to go there. Um, I also want to point out that you don't have to be in a union to use the NLRB. There's this concept called concerted activity, which you can engage in even without a union. Concerted activity is actions taken by workers together or by a single worker on behalf of a group to improve their wages, hours, or working conditions. Workers also have the right to join together to improve these conditions through actions if such actions are conducted in a peaceful and lawful manner, regardless of whether they have a union. I definitely have some tips about engaging in concerted activity, and we can get to that later on in the live as well.
Thank you. Did you want to add anything, John?
Yeah, I think thinking about the limitations of the NLRB, Abby rightly pointed out that many workers aren't covered by the National Labor Relations Act and are outside of the jurisdiction of the NLRB. But even those that are covered, um, like most federal agencies, the NLRB is understaffed, underfunded, and the result is that it often takes a long time for things to move forward. And that is a trend we'd expect to continue with Trump and Musk's attacks on federal employees and federal agencies. So that's one issue with the NLRB.
So
There's also issues with the remedies. So,
can I interrupt you real quick? Takes a long time before Trump, right? And what is that, like 6 months to a year?
it really depends on the case. But yeah, 6 months to years potentially
Mm,
before you see a remedy.
right. So you'll be ready by the 2028 general strike. Need be get started now. Okay. And I'm sorry I cut you off. Go ahead.
No. Yeah. I think another issue is that, as we discussed, it can the precedents change from administration to administration. Um, so, a lot of folks in the labor movement really believe that reform is needed here. That the NLRB was a step forward for the rights of workers, but there's a long way to go, and it's really important that workers not only organize in the workplace under the NLRB process, but also organize politically to make sure that we can make changes to this system so that it works better, so that it's easier for workers to enforce their rights, easier for folks to form a union. Because right now, even in the best of times, under the Biden administration, for example, it took way too long to form unions and for workers to enforce their rights.
Yes. And even the NLRA wasn't passed because, Republicans and Democrats wanted to pass labor law. It's because workers demanded it, and they knew that they had to do something. We have an 8-hour day because of workers standing up, and that's also why we have something like the NLRA. And what John was saying is, yeah, reform here is needed, and it's not going to happen without more workers knowing and engaging with their rights and talking to their coworkers.
So we now know what the NLRB is. We know what it is not. We know that it's a tool that will help us process our opportunities to organize within our workplaces and stand up for our rights, union or not, right? And we know the limitations, right? Most people can, or the majority can use it, but not everybody has access to it. Can you speak to now sort of what life was like before and what led to it and why it's such a pivotal tool for us to have now? I know it's almost a century old now. So
Yeah, it is almost a century old. And before the NLRA, workers had extremely limited legal protections for their collective action. Employers would hire private security forces to suppress labor movements. Violence would happen. Organizers were blacklisted, and workers could be fired without recourse at all for their collective activity. I mean, there's a lot more stuff that was happening, like uh, unions were getting hit with antitrust lawsuits, like it was getting ridiculous. So while labor unions existed before the NLRA, the passage of the act created the legally recognized right to form labor unions. It guaranteed collective bargaining rights, and it protected concerted activities for mutual aid and protection.
It's interesting to think about the 1930s and when this was passed now in particular, because the parts of the Trump coalition, most notably Elon Musk, his company SpaceX has sued to have portions of the NLRA be declared unconstitutional. And there's reason to believe that, these folks don't really believe that you should have the right to organize collectively. And if they're successful in these attacks, we may be in a situation where it's more like the 1930s than we'd like to think it could be, where folks have to get really creative about working with your coworkers to force bosses and companies to recognize you and give workers the dignity that they deserve. So it's a crazy spot to be in as a labor lawyer, to be talking about the constitutionality of a act that has been on the books for over 100 years. And, even 10 years ago, it was taken for granted that it was constitutional. But that's where we are. That's how aggressive these attacks against organized labor are. And workers need to know that and realize that that's what we're up against. And it's all the more important that folks get organized and talk to your coworkers about how you can improve your working conditions and work together to create a better world for workers.
Exactly, because everyone thought Roe was settled law. Everyone thought for the last 100 years that this is constitutional, and I think we just need to engage in very real conversations about what will happen if, they keep moving this forward.
now it's. I feel like when the Trump admin got in and with Elon added to it, it's become sort of canon. Like politics is all the more prescient for people, pressing matter. Concerted activity. Did you fully cover that?
No, I'd love to talk with people more about that because if you don't know how to engage with your labor rights, concerted activity is a great place to start. Um, so workers that are eligible under the National Labor Relations Act. Oh, quick question. I'll turn to this question in the chat because we just haven't made this clear throughout this live. You do not need a lawyer to go before the NLRB. Of course, it can help, but you do not necessarily need it. I'll give some tips about filing a charge later, but no, it is not required to have a lawyer to go before. You're able to go yourself and they prosecute the charge on your behalf. Of course, you have to be active, present evidence, give them witnesses, help them make their case, but you won't be alone through the process, even if you don't have a lawyer.
And I would add just one thing there: it's free of cost as well. There's no cost to filing a charge.
Yeah, how would one approach the NLRB, find your regional office's contact information? That is a way to do it. You can directly reach out to your regional office. You can also just go to the website. I'll go in details about this again later, but I think it's worth saying now. If you go to the NLRB's website, there's a tab up top that just says e-filing. You can click that and then click e-file charge/petition, and you can click through a charge. I strongly recommend that when you're doing that and you're going to file your charge, you have your evidence and your witnesses ready to go. But you can do that online, or you can go in person or give them a call. Those are all three great options to get your charge started.
And I think while we're on the subject, what we're talking about when getting your witnesses or your evidence together, if you're, for example, were fired because you talked to your workers about forming, your coworkers about forming a union, before you file your charge, gather emails, text messages, screenshots of text messages, um, any other documents, your firing letter, anything like that that could be relevant to the charge. It's a good idea to gather that together so it's organized and ready to be presented to the NLRB. It's good to talk to coworkers to figure out who would be willing to back you up and provide testimony to the NLRB in support of your charge. It's also unlawful for employers to retaliate against you for going to the NLRB or for providing evidence in an NLRB investigation. So if your coworkers are nervous, you can tell them if they're retaliated against, that's unlawful as well. But that's what we're talking about when we're talking about gathering your evidence in preparation for filing a charge.
Yeah, and I've seen charges be used as fantastic organizing tools. It's nice to be able to point to something and be like, look, our bosses are violating the law and there's something we can do about it here.
Wes asks, why does Elon and other oligarchs, why do they want to abolish the NLRB?
They don't like workers. I mean, they don't want you to have rights. They don't want you talking to your coworkers. They want you to live in your individualistic little silo, not thinking about your coworkers and your collective well-being. And so this is just a way for them to directly attack those rights. Organized movements have brought us so much change in the last 100, 200 years, and they see that, and especially in the last 5 years. I think if you go back to at least the last time I checked, I think this was 2021, it was the highest approval rating for unions since the 1950s, I believe, 1960s, but the lowest percentage of people in unions. And that shows that it's a policy failure and they just want to put a nail in that coffin. I don't know if you have anything to add.
No, I totally agree with that. And, I think, yeah, it's about power at the end of the day. Elon and other bosses feel like they should be able to do whatever they want with their employees. They should be able to pay them whatever they want. They should be able to fire them whenever they want. They should be able to boss them around however they want. And workers should have no say at all in response. I mean, Elon, I think it's personal too. I mean, his company has been investigated by the NLRB, and I think he feels like he should be the little king of his company, and the workers and our government shouldn't have the right to tell him what to do with his company. But workers are the ones who build the rockets that SpaceX makes, design the rockets. They're the ones who actually do the work of creating the products and the value for these companies, and they deserve a seat at the table in their working conditions and yeah, wages, benefits, all of that.
Yeah, I'll hop back to concerted activity because you don't have to be in a union to engage in that. I mean, of course, union members also have the right to concerted activity, but you don't have to be in a union. Concerted activity is actions taken by workers together or by a single worker on behalf of a group to improve wages, hours, working conditions, which are protected under Section 7 of the NLRA. And workers have the right to join together to improve these conditions through actions if such actions are conducted in a peaceful and lawful manner, regardless of whether they have a union. Like I said earlier, concerted activity is a great way for folks to begin engaging with their labor rights.
Thank you for that. I love y'all's confidence. It really makes me feel like I have something in my corner, which is a light in dark times. So Vin Diesel's stuntman asks, is it possible for a collective of independent contractors who all work through the same company to unionize, or will they just simply hire new ones, new independent contractors?
That's a tough question. That's a very tough question. independent contractors are not covered by the NLRB. So the short answer is no, that under the NLRA, independent contractors can't unionize. Uh, Slightly longer answer is that many employers call people independent contractors because they know it means they don't have the right to organize and don't have a lot of other rights. When in actuality, these folks are employees. So if your employer is telling you you're an independent contractor, you can't organize, you don't have these rights, that may not be the case. You may be an employee, you may have the right to organize. So you should contact either a labor lawyer. You can do some of your own research. I'm sure there's things online you could find about whether or not you're really an employee or an independent contractor. You could contact the NLRB as well.
Yes. Yeah, I would definitely like reach out to the NLRB. They have a helpline, which we'll also discuss more later. Because, for example, if an employer could just call all of their workers supervisors and never have to deal with the National Labor Relations Board, they would just do it. And so, you can't just do that. And so these kinds of inquiries are very fact specific. And so that would it depend on your situation at work.
And then I think it's worth addressing the second part of that question too, which is whether they could just fire folks and hire new independent contractors. As I said, if you really are an independent contractor, that may be what the employer has the right to do. That doesn't mean you shouldn't talk with it's tricky with independent contractors, but with employees, there are protections against termination. Based on formation of a union or striking, depending on the situation. But and you also just have power as the workers. I mean, it's not easy for an employer to turn around and hire a whole new workforce overnight. So you do have power when you have solidarity between yourself and your coworkers. And your employer may say, "We'll just fire you all and hire new people." It's not that easy. It's not that easy.
This makes me really want to join the fray. I've never been in one of these fights personally. And my current workplace is unionized already before I got here. But anywho, Derek Souza asks, can you unionize a trade such as social workers or caseworkers across several NGOs or nonprofits?
That's another good question. I don't know if you want to take it or.
Would you? I mean,
Sure.
yeah.
I mean, the short answer is under the National Labor Relations Act in the private sector, it's generally company by company. So you form a bargaining unit with the folks working at your firm, your organization, your company, working with other unions, other units in your industry to build power is a great tactic. But in terms of forming a bargaining unit where you bargain a contract, in the first instance, there's nothing in the NLRA that would require your employers to bargain a contract together. They could though, and there are multi-employer groups that bargain contracts with multi-bargaining units, bargaining tables. So it's not impossible to do that. It also is why many unions are international or national organizations, and they seek to organize across a whole sector. So, you can form a union of just you and your coworkers without working with a national union. But there's benefits to working with a national union because of that, because of the reasons I'm sure you're asking this question, because you have more power when you're bargaining across a sector. That's also one of the areas where reform, people really want to reform and give folks more rights to organize on a sector-wide basis like that.
Yeah, your question is getting to this concept called sectoral bargaining, which is just interesting for any of the nerds out there who just want to look into that a bit more. And yeah, it's something that people are thinking more and more about. You have some states also experimenting with new legislation. Like Minnesota recently passed a board for nursing home workers, for nurses who work at nursing homes. So they're able to all act together, and that board is split. Like I think about half management side, half labor side and workers, and then one representative from the government. So more people are thinking about sectoral bargaining, both inside and outside of the NLRA. But yeah, as John said, it's not an easy yes.
But the fact that it's happening is because people are doing it. And so talking to folks at other jobs and building solidarity is super important and something you absolutely should be doing. And this none of this is to discourage you from doing that, because even if you aren't able to form a bargaining unit with those folks, engaging with those folks and building solidarity with folks at different nonprofit organizations or whatever the case may be just builds your power.
Excellent answer. And just so I'm clear, the short answer is yes. It's not easy, but none of this is. So it's a yes, right?
It's a little tricky. Like if you're going to form a union and you don't have a union at your workplace, you're going to likely do that shop by shop. You're not going to do that across 3 different shops or 3 different, independent organizations. But once you have formed a union, then the options open up for putting pressure on employers or trying to um, leverage your sectoral power.
Okay. Well, regardless of your sort of legal status, EWOC will help you. Next question is, any tips for a recently unionized store where many employees are struggling with fear of retaliation?
Building solidarity. I mean, having meetings, doing actions together, just being there for one another. Union drives can sometimes go beyond, they can get really personal. I mean, a lot of people have a lot of stake in their work. So I don't have any stronger advice. I don't know, John.
I think this is one area where, depends on the facts of the case, but filing a charge with the NLRB can be really galvanizing.
Yeah.
If folks are scared of retaliation and someone is retaliated against, filing a charge with the NLRB can show that folks do have rights. And it also brings it out into the public. So, it's about thinking strategically about how you can kind of build that solidarity and bravery in folks to stand up for themselves. Taking it to the public, having neighbors put up signs showing that workers have support can be a way for people to build that bravery. But yeah, it's tough. I mean, I won't sugarcoat it. People are very scared of retaliation, and sometimes with good reason. It's tough.
Yeah, this is where I would also plug Ewok. Apologies for forgetting the title of the little book. That's super helpful and has some really good tips for people doing kind of exactly this work. But yeah, talk to organizers who have been through this before. You will not be the first person experiencing these thoughts and feelings, and there's definitely a lot of people out there to help give you some advice.
Thank you both for that excellent answer again. Yeah, EWOC will definitely help you here. Off top, I just think about making sure that you have a more, I don't want to use the word militant, but more structured team or group that'll make sure that you can, and mutual aid on the side, that'll make sure that you have what you need if you're fearing that, right? That gives you what you're looking for in terms of support. Next question. Can you act like a union without legal recognition? And is there such a thing as putting enough pressure on the boss to just give legal recognition without the NLRB?
You want to take the second part? I'll take the first.
Sure.
So the first part is, well, you can't necessarily bargain a contract. You would need a union for that, but you can. I keep saying it, but you can act concertedly. You can engage in concerted activity. So what that looks like is when you make an issue about the group, not just about yourself. So if you say, "I think I deserve a raise," that's not concerted activity. But if you tell your boss with another coworker, we deserve higher pay because we are all taking on additional work, that is considered activity and that is protected. And if you were to face retaliation for saying that to your boss, that is something you could take to the NLRB. So if you just tie workplace complaints to other workers, you can have protection for those complaints. So instead of saying to your boss, I don't feel safe using this machine, try saying, we do not feel safe using this machine. But of course, make sure your coworkers feel similarly first. So that's a way to engage, kind of like you're in a union, but you won't have the benefits of a contract.
So there's a process called voluntary recognition, where you would, and this may be a step you take even if you end up going through the NLRB process, but you present the boss, or tell the boss that the union has majority support. I want to say one thing really quick. Don't give the boss the list of employees who have signed authorization cards. That is yeah, you want to keep that relatively confidential. I mean, folks being out and proud is great, but generally the strategy is you want to you don't want to hand over the list of union supporters to the boss. But you can say, we have majority support and we'd like you to do the right thing here and recognize the union. Don't fight it. Don't go to the NLRB. We have majority support. Please show your workers respect and recognize us. And that's a very valid thing to do if you have majority support. And then the NLRB may get involved to certify majority support, or there's other ways to do it, but it's absolutely a viable tactic, and many employers do voluntarily recognize, especially in the nonprofit sectors and sectors that are worried about their public image. That can be a viable strategy. You can also strike for recognition. It's a little more complicated. I think the max, 30 days is the longest you can hold out on a strike for recognition. And it's not always the best strategy because employers know that's as long as you can go and they can kind of just hold out at that point. But it is an option.
Yeah, I would just think strategically about whatever you decide to do. Because voluntary recognition sounds great and it does work really well in some situations. I've also seen it go a bit poorly, where it becomes then a battle over who's in the bargaining unit and who's not. So just think about the situation, make that decision amongst you and your coworkers. Yeah.
And talking with either EWOC or a union organizer who would have some more experience is important as well.
Yeah, and also winning an election it can be pretty invigorating. So again, think about your campaign, the campaign you're running, and if that would be beneficial. If you really think you can win an election, that can sometimes feel good just to get done.
That's important to know. Okay, thank you. And next question, what do you think of the recently introduced Faster Labor Contracts Act?
Yeah. So this is for folks that may not know, it's a bill that was recently introduced by Josh Hawley, the Republican, and I can't remember who the Democrat was, but a Democrat. And it is to force employers to bargain in good faith with unions. Once you do certify a union and you form a union, you're bargaining a union contract. I think it's after a year of bargaining, you would go to arbitration, or I can't remember exactly, but basically the end result would be someone would say, this is the terms of your contract if you don't get to an agreement soon enough. Because currently a lot of employers stall and take forever to reach agreement on a contract. I think it's a great idea. I'm all for it. Call me extremely skeptical about any Republican support. I think it has almost no chance of passing right now. And if it had a chance of passing, I think there'd be fewer Republicans that would support it. But it's a great idea, and I'm all for it. And I hope it passes someday.
Okay, thank you. There was a follow-up. Was there any other recent legislative reform attempts that you all think you should highlight right now, Abby or John, i.e. the PRO Act?
Yeah, I feel like people have been talking about the PRO Act for quite a while now. That would be the reform that we have been needing and wanting in labor law. Considering Democrats never passed it when they had a majority, you know, that frustrated me and a lot of people. But the PRO Act is the biggest example of recent legislation put forward that was semi-viable to reform labor law in this country. I don't know if you have any more to
Okay.
say about the PRO Act.
No, I think, yeah, I'm all for it and think it would go a long way towards fixing some of these problems. And we need to do a lot of political organizing to get to a point where it would pass.
Yeah, because I don't know if this is clear for folks, but states cannot pass their own labor laws that impact private businesses. It is only the federal government that is able to pass labor law. So any reform would have to be at the federal level. If the National Labor Relations Act was found unconstitutional and it no longer existed, then states could pass their own labor laws. But currently, states are unable to do it for private industry.
Understood. That's more of the limitations, right? Just so you know, staying in the know right now. Next question is the NLRB at risk of being dissolved by Doge? What would the process look like? When is there a red line that you think that your ears would perk up as one in the field? Or you're like, oh, it's real now.
So at least the agency was created by a law. So it can't be unilaterally walked back by Trump. It would take another law by Congress to fully dissolve the board. But it, Doge might try to impact it in other ways, like reductions in force. I think that goes to just making things take a very long time. I forget, there's somewhere in the Northeast where they claim they canceled like the contract of one of their offices, but it actually wasn't. They were just moving, and so that's as much as I know. Doge has involved itself with the NLRB was just that one weird contract situation. That was also nothing. That was a contract going back to the Biden admin. But I guess we just don't know. But I don't know if you have anything to add.
Yeah, I mean, uh, I think a couple points. One is that I think some of this, is it constitutional? Is it what's going on? What's Doge doing? What's Trump doing to the NLRB? Gives folks the impression that now that Trump is president, they don't have rights. They don't have the right to organize. They don't have rights under the NLRB. That's not true. You do have rights under the National Labor Relations Act. You do have the right to work with your coworkers to improve your working conditions. And I think they use this chaos to make people confused about what their rights are. So I just want to be really clear on that. And I think as to whether it would be declared unconstitutional, the challenges that are right now working their way up are about the remedies. They're not a whole scale destruction of the National Labor Relations Act, but Trump did fire one of the NLRB members very early on in his administration. She's recently been appointed to the board by the courts. But there are things they can do to hamper the effectiveness of the NLRB. That doesn't change the law, which is that you have the right to form a union, and you have the right to work with your coworkers to improve your wages, benefits, and working conditions.
Yep, and board agents are still today working through charges. Stuff is proceeding. So I just don't want people to overly self-censor.
Another question, pretty straightforward. Can you be arrested for unionizing?
Not for unionizing itself purely. I mean, they could try to get you for like trespass or something, but not the act of unionizing.
No. The simple answer is no. You can't be arrested for trying to form a union. You have the right to do that under federal law.
Okay.
I mean, if you do things in the course of trying to form a union that are illegal, yes. But, for the simple act, as Abby said, yeah.
Like the corporation might try to call the police, and I've seen them like go to places, but no, you can't be arrested for unionizing.
Okay. So is there a common misstep that people make that could get them arrested? Like they didn't know it was illegal? If not, that's all too well. Just making sure.
I mean, cops sometimes do get involved in labor disputes, but yeah, I wouldn't say they're common missteps. I mean, it's pretty common sense stuff generally. I would add one thing is we're talking about the NLRA and the private sector here. You know, whether specific states have rules about their public employees or specific sectors that I couldn't comment on. But you know, generally speaking, you will not be arrested for unionizing.
Yeah, I actually, while we're on this topic, I have some tips for concerted activity where you can lose legal protections for engaging in concerted activity. And I think these are just some good principles to keep in mind when you're organizing, or if you're not even trying to form a union, if you're just engaging in concerted activity. These are good things to keep in mind. First, don't say anything or do anything egregiously offensive, like using racial slurs. You will lose protection. Um, don't make any knowingly or maliciously false statements. Anything you say should be provable. Um, Publicly disparaging your employer's products or services without relating to your complaints to any labor controversy can also get you in hot water. So, for example, if you just held up a sign outside that said, "This hospital is dangerous for patients," you can get in trouble for that. But if you wrote, "This hospital is dangerous for patients because we're so understaffed," you just directly tied it to your working conditions and you can have protection for that. And then generally, insubordination could be an issue. The NLRB is trying to balance workers' rights to concerted activity with the employer's right to an orderly workplace. So just maintain a defensible respectability in case you have to go in front of a third party, like an administrative law judge.
Just so I'm clear, if somebody comes to the event with a sign and is like, "Our boss is whack," that could put us in hot water. Is that what you're referring to, or is that
I
too? Is
I
that
wouldn't recommend holding up that sign. I would rather say like my boss is not allowing us breaks. Like just why how is your boss being whack? I would just put that on the sign.
Or
okay?
even my boss is exploiting workers, exploiting his employees.
That's
If that's the case and that's you know you've can back that up, then
anything
absolutely.
you can back up. Okay, those are excellent tips.
And I have one point on that. And
Okay.
Abby, what does it mean to lose protection? Does it become again? Can you get arrested then if you do something that loses protection?
You can't get arrested, but you probably won't win your charge. If it has to go in front of the board, I don't.
Yeah. So, for example, if you brought a sign that said "Your boss is whack" to the labor action that you're doing, and you get fired because you had a sign that said "Your boss is whack," the board may decide that you've gone too far and not investigate or not move the charge forward, find merit, and try and get you reinstated. If you have a sign that said, "My boss doesn't give us breaks," the board is almost certainly going to find that you're protected, meaning you can't be retaliated against. So losing protection doesn't mean you're breaking the law. It just means that you could get fired, basically.
Okay. Is the board uh, uh, a neutral third party, or are they openly biased towards those trying to unionize? And how different does it look between Biden's admin and Trump's?
Great question. I'm going to split that up in the first part. It is within the statute, so the law that made the NLRB, that they support unionization. Like they are here to help people engage in organized activity. So they should be pro-worker. It is a pro-worker agency. I don't know if there's any other agency that can explicitly state that as strongly as NLRB. And then the second part of the question, the differences between the Trump and the Biden board, it goes back to that interpretation of the laws. The Biden board had a much broader interpretation of what our rights were. So, for example, they developed the concept of remedies, where instead of maybe just getting back pay, let's say you also got booted off of your company's insurance unjustly because of this illegal firing, and then you got injured and you had to pay more out of pocket, the Bruzo board, the Biden board, was more likely to allow you to get that additional money that you had to spend because you lost your insurance. while the Trump board, they might not have that same interpretation. So that's kind of where the differences lie there.
I think the boss is whack example is a good one to show the difference. Under Biden, under the Biden board, if you went to a protest at your workplace and with a sign that said the boss is whack, the Biden board's probably going to say you're protected, you can't be fired for that because that was you standing up for yourself and your coworkers. The Trump board might say you went too far with that one, you can be fired for that. Both the Biden and Trump board likely will say if you throw a brick through your boss's car window, you can get fired for that. Both the Biden and the Trump board will say if you hold up a sign saying pay us more, that's protected and you can't be fired for that. Does that make sense?
That's a perfect answer. That clarifies. Thank you. I had a question, but I'll just read this one. Can you talk about the PERB and how it differs from the NLRB?
PERB, so the Public Employee Relations Board. Different states have different systems for their public employees, state public employees. Federal public employees also have their own system that's separate and apart from the NLRB. So oddly enough, if you're an NLRB employee and you're wrongly terminated, you won't use the NLRB. You'll use a federal system. And I think it's somewhat beyond the scope. We just can't get into each state. But if you're a public employee, the system is different. You should talk to an attorney or a public employee union in your state.
I had a thought in the vein of the reality check, sort of. You've named a few ways where you could mess up your claim and not be unionized, or they wouldn't accept your charge, right? What happens then? Do you just start over from ground one, or are you like for life in that situation? What happens after you, heaven forbid, do not move forward with the process?
Well, are you talking specifically unionizing or like an individual was fired?
If you are trying to unionize and the board says no because somebody held up a sign that said they're whack, their boss was whack, or something like that. Does that make sense?
So I think this is a good point of clarification. That wouldn't affect your right to unionize.
Okay.
That would affect whether your boss could fire you for taking part in that activity. But you can still unionize. I mean, that's separate and apart. There's nothing you can do. Well, yeah. I mean, generally speaking, your right to unionize is you and your coworkers' rights. So it's not just you. If you do something egregious, your coworkers still have the right to unionize. So you might be fired, but your coworkers can move forward with their fight to get unionized.
Yep, and you can keep trying at that too. If you lose your first election, you can absolutely have a second one.
Yeah, I think that was my question then. Thank you so much. Let's wrap it up. Let's recap, right? What we've experienced, and maybe add a call to action on the end of this if there's anything specific that you two would recommend. Other than, of course, let's not forget, go check the NLRB website and find your regional office, or just e-file if you need to do that right now. And for anything else EWOC related, please, if you're trying to organize with your coworkers, please reach out. Link in bio. You can volunteer to just help others do so if you're not ready. You can get support if you're ready to do so yourself. Check it out. There are training courses so that you can be on the other side, helping people organize as well. That's all available to you. And there's a book in the link for you to figure it out. Union 101, right? So, Abby and John, can you please recap for us, wrap this up?
Sorry, I'm just highlighting Unite and Win. It's Ewok's book. It's fantastic. Totally recommend anyone thinking of organizing to pick up one of these books. They're just great. So I think I just want to highlight one more point. We've talked about charges, how easy it is to do online. I just want to reiterate, after you file, be checking your email. It's an active process. You will have to be engaged in the process, or the NLRB, they might dismiss it for lack of cooperation, or just sit on it for a long while. And if they start sitting on it, do not be afraid to pester the NLRB agent assigned to your case. These are your rights, and sadly, in our country, we typically have to enforce our own rights. But that's just something good to know as we are going into this administration.
Absolutely. Yeah. Just keep up the fight. You know, you have the right under the law, and you have the moral right
Yep.
to work with your coworkers to improve your working conditions, regardless of what the law is. You have the moral right to do that. And Trump can't change the law on his own, and he definitely can't change your moral right to stand up with your coworkers.
Beautiful. I'll be the one to go ahead and add. It is your duty to organize. If you can do it, please do so. I have this dream that everywhere is organized. That's why I volunteer for EWalk. That's why I'm here. That's why we're all here. So thank you all for being with us. This is not the last. This is the first. So look forward to maybe John and Abby coming back and speaking further. Maybe we'll check in 6 months or a year. But we'll continue to bring the questions that will help you feel like you have the tools uh, in these trying times, right? So that you know what to do, so you know how to move. Thank you all.
Thanks
Thank you so much.